important issue which is really going to touch the Supreme Court. And the topic today we have chosen is Indian Supreme Court and homosexual unions. And I'm very happy that we have with us this team, attorneys from the Supreme Court, and my own Dr. Adityanji will facilitate this program and take it forward. So Adityanji, please.
Thank you, Vivekji. This seminar is being organized on the platform of FISI, which stands for Friends of India Society International. If we go to the history, FISI as an organization was initially constituted by Ambassador Bhishma Agnihotri in 1975, around the time when emergency was declared in India. And FISI as an organization in its various forms has been friend of India, people of Indian origin who have love, affection, and connection with India as the motherland. Whenever there is some major problem, FISI has risen to the challenge and tried to help the mother India in the time of crisis, starting from emergency onwards. As a platform, we conducted recently at least 2 seminars on judicial reforms in India. So we have been looking at the judicial scene in India with a very close microscopic viewpoint. And at this point in time, it appears that situation is going from bad to worse, and there are forces involved that are trying to change the basic governance model of India. Republic of India has 3 co-equal branches that include executive, legislative branch, and the judicial branch. But it appears that for last few years, the judicial branch is trying to usurp the power of legislative branch as well as the executive branch. Decisions after decisions are being taken by the judicial branch without taking any input, either from the legislative branch or from the executive branch. The judicial branch of the republic is inserting into domain of the executive by wanting to decide who becomes the Chief Election Commissioner of India, by appointing judges, and by having a say in the running of the armed forces of India, thereby, in their naivety, weakening the defense posture of India. So this is not a single issue problem. There's a trend, there's a pattern by which the judiciary is becoming one all and trying to upstage the other branches of government. And it has serious impact on the future of India, because the way decisions are being taken, the way decisions are being enforced, does not bode very highly for the Republic of India as a democracy. We have a situation where, on the basis of several PILs, Supreme Court constituted a constitutional bench, 5-member constitutional bench, legalize or trying to look into issue of legalization of a civil union or marriage among same-sex people. The personal law in India is different for each community. And since the judicial branch at this point in time cannot interfere with the personal law of certain communities, Supreme Court judicial bench is giving clear-cut indication from the bully pulpit that they are likely to modify the 1954 Special Marriage Act by changing the wording in the Special Act from marriage being a union between a man and a woman to marriage being a union between two persons. That has been said by Justice Chandrachud from the judicial bench itself. As I said that in past discussions, FISI has had some deliberations on judicial reform, but that was done by people, NRIs and OCIs sitting in United States. Today, we are fortunate to have two senior advocates who are practicing advocates in the Supreme Court of India. Both are deeply involved in an attempt to reform the judicial system in their own ways. And one of them is Shri Subhash Jha, and second one is Madhav Mukul Tripathi. So we are going to hear from both of them their viewpoints on this particular topic. I will first invite Subhash ji and then invite Madhav Mukul Tripathi ji. I would hope that each of them will take 10 minutes to give their opinion, their understanding of what is happening about this particular issue, how the constitutional mechanisms are breaking down, and how the judiciary is trying to usurp the legislative branch. It's the function of the parliament to change the law. It's not the function of Supreme Court to lay down the law. Their job is to enforce the law that is legislated by the parliament. So let's start with hearing from Mr. Prakash Jha, a senior advocate in the Indian Supreme Court. And Subhash ji, you have around 10 minutes to make your presentation.
And
After both the speakers have given their presentation, we will have some discussion. So let's start with Subhash ji. Subhash ji, the floor is yours. Kindly start.
Thank you, Dr. Aditya.
If I may request, one second, if I may request everyone to please mute your phones so that there is no interference and we can hear it properly. Thank you, Subhash ji. Please continue.
Dr. Aditya, thank you so much. The manner in which you have defined the problem facing the Indian judiciary and more particularly the Supreme Court throwing challenges to an elected government of the day. I think this could have been defined not in better words than what you have, the manner in which you have explained. Though I do not think that you hail from the law background, but you seems to be having, I have been watching you, I have been observing you, you seems to be having extremely good knowledge of what is happening in India and Indian laws. Now, the topic of discussion today, interference of judiciary or the Supreme Court itself or the High Courts seeking to legislate. Dr. Aditya has rightly said that we have got three wings of democracy: the legislature, the executive, and the judiciary. Judiciary is only one of those three limbs or pillars of democracy. But what is happening, as Dr. Aditya has rightly said, in the name of interpretation of law or interpreting or the constitutional rights of citizen, the Supreme Court went on usurping the powers which is not there with them. Now, unfortunately, in the past, and this has not started now, let me tell you, this has started by Indira Gandhi, as she then was the Prime Minister of India. She is the one, after having lost election, her election was declared null and void by Allahabad High Court. And then with a view to overthrow, and if I mistake not, it was Justice Shah who overturned her election. And with a view to overturn then in the process of appointing Justice Ray, the Chief Justice, she in a row, she she bypassed many judges of the Supreme Court who were much more senior, and in the process, many judges had resigned, submitted their resignation. So it was all started by her. I've had a discussion with one of the most prominent speakers who is no more in the world. But according to him, his studies show that it was all started, not even Nehru tried to interfere so much with the judiciary, but it was all started by Indira Gandhi. And then, emboldened by such move, the judiciary kept on interfering in the matter of legislative decisions, or rather went on making laws. They went berserk, they went haywire. There was no control, or nobody was there to tell them that, look here, you remain in bounds, and then every organs have its own function to perform, and judiciary cannot certainly encroach upon the function of the legislature, and vice versa. Now, coming back to the issue, the problem which we are facing, I have made some research, and I find that the recent problem, or the problem with which the Supreme Court is dealing with, so-called problem, is of whether there can be marriage of two of the same sexes, whether a man can marry another man, and women can marry another women. That is the issue which is being deliberated by none other than the Constitution Bench of the Supreme Court of India. And then look at the manner in which this matter is being heard, and I'll take you to the historical background, a little background of how things have started changing. It all started with Sabrimala's case. Now, Sabrimala's case was whether women of certain age group, between, if I mistake not, it is 14 to 50, whether they should be permitted or not, should not be permitted to enter Sabrimala temple, and why they should not be made to enter or permitted to enter. There is a history. We have to go back to not seek law or go to London or America or UK or Europe. We have to see why such practices have been followed in India. Now, Sabrimala is a temple where Lord Sabrimala is in the form of a yogi, a sannyasi. A sannyasi therefore has to perform his own rituals. Now, one of those rituals would mean that he has to keep women away from him. Now, there is a process. Whenever there is an idol which is to be installed in any temple, we have the process of undergoing what is called pran pratishtha. Now, that process of pran pratishtha would mean that the idol is in the form of a living God. And therefore, we have the arati, we have bhog. भगवान को, ईश्वर को हम भोग चढ़ाते हैं, उनकी आरती करते हैं, उनको खिलाते हैं. इस तरह से हमारी प्रक्रिया शुरू होती है. So therefore, this bhog and this arati, etc., is performed as if the God is living. Therefore, whenever we say we go to temple for darshan, nobody, neither in the Christianity nor in Islam, or for that matter any other religion, they say that we go for darshan. दर्शन उनका किया जाता है जो प्रत्यक्ष विद्यमान हो उस मंदिर में. So therefore we say that we go for darshan, and it is believed that the God is living in that temple where we worship. So therefore this is the striking difference, and therefore women are not allowed, because a sannyasi is required to keep women away from him. Otherwise, how does he practice sannyas dharma? Unless and until he has to take the route of Gandhi, which was so flawed, an idea of testing himself whether he is a sannyasi or otherwise. I mean, what kind of mindset was it? So it all started with Gandhi trying to do something which is absolutely rubbish. Now, that apart, so therefore God is living. And therefore, if you have to follow, and you have to decide the issue of Sabrimala, you must understand what is sannyasi ka dharma. Sannyas का क्या धर्म होता है, एक योगी कैसे अपने जीवन को यापन करता है, ये आपको समझना पड़ेगा. Now, instead of going to India, Now, which is the only country where sannyas dharma is practiced even now. So therefore, instead of finding solution to the problem in our own text, religious textbooks, they went to US, they went to Australia, they went to Canada to find out which author has said what, and try to do it as if everything, the solution lies to all such problems in the constitution. This is such a flawed idea. Constitution of India, or for that matter, the several laws which government keeps on enacting, is not the solution to these kind of a problem. The problem lies in our religious texts. You should have consulted our religious scholars to find out what the solution is. Now, how a religion is to be followed, and that to a Sanatan Dharma is to be followed, is not for any court of law, and certainly not for the Supreme Court to adjudicate upon. Something which was not done even by the British has been done by the Indian Supreme Court by deciding, redefining that the constitutional right of women. And now, who were those women who were seeking constitutional rights? I may tell you who filed the petition. It was Young Lawyers Association which filed the petition. Now, who were those young lawyers? When we file a petition, Matrabhumi files a petition, we are asked, what is the locus standi? Who are you? Are you a political party? And then our backgrounds are checked instead of going to the merits of the matter. Here in this case, reverse happened. Nobody found out as to what is the background of these people. Whether these people ever had gone to Sabrimala temple. Have they got any association, affiliation, or respect for Sabrimala temple? Now, instead of doing these checks and balances, which are so basic, so fundamental, the Supreme Court went haywire and went to interpret as if this is such an important issue and which is to be resolved by constitution. Then came 377 of IPC. Now, 377 of IPC is nothing but unnatural sex. So Supreme Court went on to decide and strike down 377 that if a man is having sex with another man in privacy with consent, it is justified, it is legalized, and there cannot be any prosecution. And then again, once again, fell in error in my assessment in trying to find solution with the constitution. You really can't find solution from the constitution or derive such strength from the constitution, because constitution is not the answer. It is again our religious text, our religion practices, religious practices, or the traditions which our country follows. The solution lies there. The Supreme Court went on trying to again find, saying that this is constitutional right, this is freedom of expression, now this is orientation, and now comes the same-sex marriage. Now, therefore, I see same-sex marriage is nothing but an extension of 377. So it was systematically, petitions were filed in the Supreme Court, and the judges knew how petitions would be filed and how they are required to be dealt with. Let me tell you, 3 judges who were responsible for these 3 important decisions, starting with Sabrimala, and then 377 IPC, and now same-sex marriage. Justice Chandrachud is common in all 3 judgments. Now, Sabrimala and 377 IPC, the Johar Singh case,
it's a
there
meeting.
were two more judges who were common. One was Justice Deepak Mishra, as he then was, and Justice Rohington Nariman. So Justice Deepak Mishra, Rohington Nariman, and Justice Chandrachud now will decide and redefine how the Indian society or how the Sanatan Dharma is to be followed in the country. Now, this is so absurd. And look at what is the argument. The argument advanced is that, look here, it is sex orientation. So now tomorrow, I came on a TV channel and I exactly said the same thing which I am repeating. I said, tomorrow you may have orientation to become a judge of the Supreme Court directly. I am a practicing lawyer. Mr. Tripathi here, Mukul Tripathi, is a practicing lawyer. We decide to become judge of the Supreme Court because this is our orientation and we have deep knowledge of laws. How can you deny our constitutional rights? tomorrow I decide to become, or we orientation, or a lakhs of people or crores of people in the country have orientation to become Prime Minister of India. Will they become Prime Minister of India? So what is this orientation? Where do you get this flawed idea of orientation from? And tomorrow, forget about that. So one person who was there speaking on the subject, he said that, no, this is career orientation. So tomorrow you may have sex orientation to have sex in public. And as Tushar Mehta has rightly said, the Solicitor General of India, that tomorrow you have orientation to have sex with your close relatives, your mother, your sister. Where are we heading for? Where the Supreme Court is taking our society to? It is taking our society to disaster. Now, in our Sanatana Dharma, which we follow, there is called Gotra, that is called Mool. Now, Mool possibly has been given way. Otherwise, whenever there is marriage discussion, proposal for marriage, the first thing which they will find out as to what is your Mool. Now, Mool possibly, subject to what Mr. Tripathi has to say on this subject, I have no much knowledge, but Mool in my assessment has been given way. But now certainly, whenever you go for marriage, say for example, if I have to marry my son or daughter, I will find out what is Mr. Tripathi's daughter's or son's Gotra. Samagotri, same Gotra marriages are forbidden. And it is scientifically proved that if such marriages takes place in the next 3 to 4, 5 generations, that family will be decimated completely. There is problem. This is medically proven, scientifically proven. So therefore, if there cannot be marriage between the same Gotra, how can there be marriage between two same sex? Men will marry men, women will marry women. Where the society will be heading for? Where is the procreation? How will the society develop? How the children will be born out of two males? Can two males give birth to a child? And vice versa, can two females give birth to a child? The answer to that is emphatic no. So therefore, what is the solution? Surrogacy. So surrogacy will be deciding now the fate of this country, and the Supreme Court wants to hear this petition. In my assessment, this is absolutely flawed idea. And on one channel, when I had come, I had suggested that look here, time has come for the Parliament to intervene. Let the Parliament call a special session to discuss, deliberate on this important issue and restrain Supreme Court. Now, Supreme Court has been doing everything which is not in their domain. Let the Parliament do something unprecedented. This is an unprecedented challenge which has been thrown on this country by none other than the Supreme Court of India. And therefore, the solution to that is unprecedented. The Parliament has to intervene and stop the Supreme Court from deliberating on such frivolous and vexatious issues which have been foisted upon us. Look here, when the petition is filed, it is filed in the month of October 2022. On 13th of March 2023, a 3-judge bench headed by Justice Chandrachud then places the matter before the Constitution bench, and then from 18th onward, the 18th of March, the Constitution bench starts hearing the matter. Is it not a case of out of turn hearing? In the matter of Sapna Chaudhary, not very long ago, Justice Bobde, he was heading the bench, deprecated, a 3-judge bench deprecated the process of hearing out of turn. Is it not a case of out of turn hearing? What is so urgent? Are they not supposed to wait in the queue? So therefore, in my assessment, now this is an engineered petition, and somebody, I do not know why it has not been argued, that find out why this petition was filed. This petition, in my assessment, was filed systematically, saying that you have a judge of your own mentality or own mindset. And then he will immediately, and he being the Chief Justice of India, will embark upon to take the matter and hear the matter. Now, you have said recently in the matter of that West Bengal judge, Mukhopadhyay. Mr. Tripathi, is he Mukhopadhyay or Chattopadhyay? Now, in that case, you have said that, look here, having spoken in the public, you should not be hearing the matter. Now, how many times Justice D.Y. Chandrachud has been speaking on the subject of so-called rights of these elements in the society, which is nothing but mental and psychological sickness. And therefore, that has to be cured by medicine. That has to be cured by psychological treatment, which is to be given, psychiatric treatment, which is to be given to such elements. And the society cannot be certainly decided and determined by such elements who will be shaping the fate, the shape of future India. Sanatan Dharma, this, in my assessment, is a very, very dangerous trend and which will lead to disaster. And we cannot permit ever these kind of elements to flourish, or these kind of idea even to persist in our country and being carried further. Thank you, Mr. Aditya.
Thank you, Subhashji, for your presentation. Just since we are on record, the election of Indira Gandhi was overturned by Justice Jagmohan Lal Sinha of Allahabad High Court. Mrs. Indira Gandhi filed an appeal in the Supreme Court, but before she filed an appeal in the Supreme Court, or during that time, in a dictatorial method, the Constitution was amended by, I think, 42nd Amendment. And by virtue of that amendment, the election of Prime Minister and the President and Vice President could not be challenged. And because of the basis of that constitutional amendment, she was given victory in the Supreme Court that her election could not have been challenged. That was one issue. I think you are raising a very important issue, that since we have three co-equal branches of the Republic, and generally it is the judiciary which has been giving direction to either the legislature or the executive, I think it is important for the legislature to exert and assert its own rights and tell the Supreme Court, have a sense of Parliament resolution that any complex, multi-dimensional issue, change of law has to be legislated by the Parliament, and Supreme Court should stay away from that. So that would be a symbolic function. Lastly, the West Bengal Justice, High Court Justice, was Abhijit Gangopadhyay. That was referred to. I guess before starting the actual discussion, I am going to invite another senior advocate of Supreme Court of India who would be speaking to us. Madhav Mukulji, kindly finish your presentation in 10 minutes so that we have time for discussion. So the floor is yours, Madhav Mukulji. Have we lost Madhav Mukulji? He was having some electricity issue.
He's not online.
Okay. I know he had joined and then there was some electricity loss in his house and there was total darkness. So I'm not sure he is able to join. While we try to connect with him, we can have certain informal discussion with Subhashji. Subhashji, when the Solicitor General, I think Tushar Mehta, yeah, when he made his presentation, he had brought out other issues. In the complexity of the law, in India, although everybody is equal before the law, but there are a number of special laws that are meant to protect women. in terms of maintenance, in terms of support, in terms of, dowry related issues, in terms of domestic violence. Has the Supreme Court deliberated what will happen if they, quote unquote, dictate same-sex unions to these laws? Where would the protection come? As the law stands today, any biological male relative of a woman is responsible for providing maintenance lifelong. Whether the woman is married or not married or divorcee, if the father is not there, the brother, the son, and in one extreme case, actually, brother-in-law is being asked to provide maintenance. So let's say in a hypothetical scenario, same-sex marriage is approved between two women who are self-sufficient. And let's say that is followed by divorce. What will be the implication for maintenance and sustenance for a divorcee from a same-sex union? Has Supreme Court thought about it?
You've asked a pertinent question. And I'm sure the Supreme Court has not deliberated on this issue. So far, I don't think the argument has taken place or concluded. So certainly this issue somebody will definitely be raising this issue as to what about the maintenance? Who will pay the maintenance in a situation like this? Dr. Aditya, I cannot even imagine in wildest of my dream this kind of a completely flawed idea of there being marriage between two sexes. How many laws we are going to change? Now, so far as the maintenance law is concerned, let me tell you, Hindu Marriage Act 1955, it was enacted in 1955, was the first act which brought to the statute book the concept of something like divorce. Otherwise, there was no divorce. Talaq is the Urdu word. Talaq is the Urdu word. So before 1955, the Hindus never had the concept of divorce. The divorce idea was brought to the statute book in 1955 by the then Congress government in power. Now, even when under that act, the maintenance can be demanded equally by men from husband, from the wife, and wife from the husband. Now that's the striking difference between that enactment and the enactment came subsequent thereto. But in 1973, by way of section 125, which talks of maintenance under the Code of Criminal Procedure, when it was amended, 1973, it talks of only maintenance being provided by the husband to the wife. So the husband cannot take maintenance from the wife. And then the law went in the same direction. Then came the Domestic Violence Act, subsequent thereto, much later. And the Domestic Violence Act also makes a deviation. It talks of maintenance being provided only by the husband and not by the wife. So, Dr. Aditya, you have raised a very important issue as to who will pay the maintenance. And now, what is the life cycle of such orientation? So today you have an orientation to have sex with another man. I mean, this is so absurd. I cannot even, I feel ashamed that my Supreme Court of India is having deliberation or discussion on such flawed subject when there are hundreds and thousands of pending litigation. The Supreme Court has got time to discuss on this. So what will happen to that? What will happen? Are you going to change all the laws? And then tomorrow you have orientation to have. If orientation is so important, they've coined a word orientation. Now today you have orientation to have sex with another man. You will marry him. Tomorrow you will have orientation to have sex with another woman. So you will marry another woman. So man will become women, women will become man. I mean, what kind of idea is this? Where the Supreme Court is heading for? I mean, I really fail to understand, Dr. Aditya.
In the same vein, if Supreme Court were to use the idea of orientation, there's a very strong movement in the West, and I have to talk about trying to justify pedophilia as a natural orientation. There is an association in United States called NAMLA, National Association of Men-Boy Love Association. So if you talk about orientation, would you also at some point in time, on the basis of same argument, the Honorable Supreme Court of India justify pedophilia?
Dr. Aditya, on the same line, if you see the argument on the last occasion, which was advanced on behalf of the Government of India by Shri Tushar Mehta, the Solicitor General of India, he said exactly the same thing. So it is stepping stone, as 377 gave rise or birth to this kind of a petition being filed, saying that there can be marriage between two sects. Now, tomorrow, therefore, Dr. Tushar Mehta rightly said that what about incest? So tomorrow you may have orientation to have incest sex. I mean, where are we heading for? And you have rightly said pedophilia. What will happen? Though they will say that it is our fundamental right. It is our fundamental right to have sex with a small child of 4 years or 5 years. I mean, so therefore, this so-called orientation must pave way or give way to the public morality, to the religious practices, to our Sanatan Dharma, to the traditions, to the ethos of the country. It cannot be this so-called, and in the name of or under the garb of orientation, you cannot do and undo anything and everything which is possible. No. The answer to that is no. It is the law of the country or the tradition of the country, the culture of the country, which has to be followed ultimately, and not this kind of a flawed orientation.
There are 60,000 pending cases before the Supreme Court of India. And you talked about, out of turn allocation to a constitutional bench. Should the parliament, should the executive not benchmarks on the Supreme Court in deciding the pendency of the cases before taking a frivolous PIL?
Dr. Aditya, just see the danger. The danger is that we have in the form of constitutional amendment something called Article 51H of the Constitution. Now, 51 is the H talks of fundamental duties of a citizen. And those fundamental duties would mean to include protection, preservation of animals, our natural resources, and so on and so forth. Now, it would mean to include eradication of corruption from the system. Now, what is happening? The danger is this: that Supreme Court went on again making laws saying that, look here, we want to curtail filing of frivolous petitions. Now, in the name of filing frivolous petitions, they have themselves said that, look here, there is in the name of PIL, one of the judgment which is of the Supreme Court, they say that PIL would mean paisa interest litigation, publicity interest litigation, and so on and so forth. So therefore, in the name of curtailing filing of such petitions, they went on restricting filing of PILs. And now if they directed that every state every high court shall have its own mechanism own rules as to how the PILs are to be filed. Now, those PILs which are to be filed, those rules which have been framed by the high courts, by different high courts, have not taken into account what about fundamental duties of a citizen. So if a judge, and let me tell you, Dr. Aditya, I have not seen this kind of a corruption in the judiciary in 37 years of my practice. What is happening? Genuine petitions, if genuine petitions, if filed, they will be thrown out of the court in the name of the petition being frivolous, or you have no locus standi, or you don't fit into that rules, and whereas the other petition may not fit into those rules are being entertained. It is a need of the hour. There are two things which the government must do, and for which we do not have any law for the time being in force. First and the foremost, we have no mechanism, we have no law in our country as to how our judges are to be appointed. One, and we haven't made any enactment to make our judges accountable. Why should a judge be not made accountable when the Prime Minister of the country, who is heading the government, is responsible? How can our judges, there are so many numbers, the Prime Minister is only one, and if he can be made accountable, then why our judges should not be made accountable? Look here, the Prime Minister of India, and I consider him the most dynamic Prime Minister that we have in our country, at least except Nehru. I've seen everyone. Now, therefore, what he said when he was called for 50th years of our bar, AAWI, Advocates Association of Western India, he was called in Mumbai to give a lecture, and he said precisely the same thing. He said that, look here, if we commit a mistake, he said to judges that, look here, your job is so responsible. They feel, people of this country still feel that they come in a temple of justice, and therefore you are God to them, to a large number of people who go to the temple. And so therefore your responsibility is so enormous. If we commit a mistake, in the next election, we will be thrown out. But you can't be thrown out, even by the election process. So the question is, we have to deliberate, whether the position of a judge is such that the moment he becomes a judge of the High Court or Supreme Court, he becomes immune to all the problems. The answer to that is no. He will rather remain immune to all the problems with which a human is infected with. He is part and parcel of the same society in which we all are living. So if Dr. Aditya and Subhasha or anybody else on this platform is having certain flaws or certain inborn qualities or deficiencies, those judges will also equally have those kind of deficiencies. The question is, what is happening today's practice? If an order is passed by a subordinate court, say for example, a court of a magistrate or a court of a civil judge junior division, it will be challenged before the sessions court or before the court of civil judge senior division. That judge will set aside the order. Now, then we'll do whatever he likes at the most. He may not do it. He may concur with the same view. Maybe if that order is obtained fraudulently by indulging in corruption, what he will do? He will do nothing except to set aside that order. Similarly, if the order is passed by a senior judge, by a judge, civil judge, senior division, the High Court will, it will do? It will set aside the order, remand the matter back, or do whatever it likes. But taking action, making them accountable to these judges is not, there is no enactment for the time being in force. So therefore,
I think we have him frozen, connectivity issue again. Let's see. Subhashi, you got frozen. So we are having actually connectivity issue from India. Madhav Mukul Tripathi has network problem and we lost Subhasha again.
Yeah, I got.
Yeah.
I
Please
think
go
it
ahead.
was disconnected briefly.
Yeah, yeah. Please go ahead.
So therefore, there is no accountability as to how a judge should decide a matter on a given day or on any other day on identical set of facts. So he can afford to make deviation. And why such deviation is made? The law is one. It doesn't change overnight or the very next day or on the same day. So you can't keep on passing orders in a different manner on identical set of facts. And if you do it, it has to be actuated by corruption, corrupt motive. What do we do to eradicate corruption? Corruption is the biggest issue in our Indian society. And if the corruption has crept in our judicial system, is it not required to be eradicated equally? The answer to that is yes. So what is the legislation? Where is the legislation in place? Where is the judicial accountability bill or act in the place? There is no. Where is NJAC was struck down? Now this government now NJAC, formation of NJAC or bringing to the statute book is the mandate under the constitution itself. So what this government did after coming in power in 2014, the BJP government, the current BJP government, is to bring to the statute book NJAC. NJAC was struck down by a constitution bench saying that it is unconstitutional. Now, since it was struck down, we have no law in our country as to how judges in the higher judiciary are to be appointed. And let me tell you, now this is the biggest problem, or this is rather the sole problem of all the ills with our higher judiciary is infected with. Now, the government of India, what it should do is to immediately bring to the statute book something like NJAC or get it restored or file a review petition and say that this judgment is flawed, it is required to be reviewed or modified, but bring it to the statute book. Let the judges be appointed by a mechanism. There cannot be. See, it is what is happening today. The judges in the higher judiciary is appointed by a procedure which is followed, which is so flawed. So tomorrow, if I like A judge or B judge or a C judge, now what is happening in the Supreme Court? A gay judge, a person who is gay, B.N. Kirpal's son, Justice B.N. Kirpal, who was the Chief Justice of India. His son, Saurabh Kirpal, is being pushed by the Supreme Court. The Supreme Court says that, look here, so what if he is a gay? He should be appointed as a judge of the High Court. Now, where are we heading for? Is this not the need of the hour for the government in power to step in and stop this? This cannot go on, and the government should not permit it to go on. You're not audible, doctor.
I'll take a couple of questions from the audience. Vivek Sinha ji wants to say something. Vivek ji, you raise your hand.
Yes, yeah. Thank you, Adityanji. And so, basically, I think you just touched upon the point which I really wanted to ask you about this collegium system, which we had discussed on this platform in very detail. Thanks to Adityanji again. And if government under this, I don't know which public outlash or it's just the judiciary not able to push even the things like NJAC, would they have courage to go against defining the role of the Supreme Court judges? So what would be the mechanism for government to push that, hey, this is something needs to be done?
See, if the judges in our country are to be appointed under a law and make them accountable, I'm sure this kind of, or deciding matters like this, striking or rather deciding issues like Shabrimala, deciding issues like 377, deciding IPC, deciding issue like same-sex marriage. Now, these are the matters which makes the judges liable for action being taken. If had we in place something called Judicial Accountability Bill or Act in place, but we have none. So therefore, the government of India should not hesitate and must bring a legislation immediately. And that is not the government of India will be doing something illegal. It is the constitutional mandate. It is in the constitution itself that the government of India has to come out with NJAC. NJAC was struck down on certain issues. You rectify them and bring it again back. So simple to the statute book.
I think that is definitely something the government of the day. And if the government does not do, maybe a private member's bill can be brought in the parliament. Legislative branch has equal co-power. So a group of MPs can bring another constitutional amendment bill, whether it is sponsored by government or not, in the Lok Sabha, bringing a version of NGAC that does not have the so-called defects that Supreme Court struck down on. But ironically, India is the only nation where judges appoint judges. And let that be on the record, that only country and only democracy where judges are appointing judges. So, there is a saying in Hindi, "Andha baante revdi, fir apne ko de." And that is what is happening, that you have judicial dynasties appointing their sons and daughters and nephews and nieces into position of judges.
I think Aditya, this discussion what we are having, this might because more public discussion on these topics may bring some push to the government that, hey, this is public is looking for this, public is watching this. There's this disparity of the power what Supreme Court judges appointments, as simple as that needs to be taken care. Maybe more discussion needs to happen.
I'm going to invite Satya Dosapati ji because he has raised his hand.
Yes, please.
He's been waiting. Be brief. I know you always have very passionate arguments. Be brief and specific in your question.
Yeah. So, I mean, I agree with Subhashji, whatever he said about the government, the Supreme Court and all this. I want to ask one question. When I visited India, January, December, I visited quite a few temples. And on the walls of the temples, there is explicit images of sex, the gay sex, explicit, very explicit. So these forms of different forms of sex is recognized. Is recognized and acknowledged by our society what millennia. Even today, when you go to a housewarming session, what is that they call? Some people, transgender people, are invited at the first time who will be given food and all that. So it's a very liberal and very open society, and it understands suppressing is not going to work. And there is a third gender is there, it has been acknowledged by our Hindu civilization. So my question is, where does this all fit into this debate? Of course, this is Chandrachud is following the Harvard agenda and all that kind of stuff. But there is an angle to it the Hindu civilization accepts, and it's of course only on the walls of the temples, because it is telling you have to bypass, you have to transcend the sexual desires or these desires to be able to enter the halls of the divine. So it's a beautiful meaning. But I want to ask this thing, what is your opinion on that?
There is I think you're referring to Khajuraho temple where
no, it's even in Karnataka temple we were visiting, and it was explicit, the sexual poses.
No, sexual poses, I do not think that anywhere, I have not heard at least of there being of the same sex. Khajuraho temple is one of those places where, which is widely referred to, but then there is no same sex. The sex between a male and a female, yes, there are images. But I tell you, what is the background of that?
No, Subhashji, please. It is the male to male sex. It's not male to female.
Anyway, I may tell you that I have absolutely no idea of a male to male sex being depicted on the temples of any wall. We will have to find out when the temple came into existence. And if we have people today there of such mentality, there may be people in the past also. And if someone has done it, this way, depicting this kind of a sexes, that doesn't mean that it is justified or ratified. By and large, you have to see the society, by and large, our dharma, by and large. If there are some elements like this in the past also, and somebody has made images, that is not certainly binding on each and every person of this country.
No,
By and large, see, this is against, one thing is there, that this is against nature. Have we seen any animal or living creature having sex between two same sexes? The answer to that is no.
No, not true. Animals do have male to male sex, apparently. That's what I was told.
I
mean,
it's a very, very complex issue. Leaving aside moral justifications, Sanatan Dharma has been very liberal historically, but that liberal nature did not mean that you normalize
Yes.
a behavior pattern for the mainstream society. Yes, it was accepted, it was tolerated, and that's the beauty of Sanatan Dharma, that it does not condemn you to hell, unlike certain Semitic religions. The issue is not that. I think issue is separation of powers and the indecent haste by which Justice Chandrachud, who was given an award at Harvard University, within first 3 months of his becoming Chief Justice of India, is he following a set agenda which is not in national interest? Because the same Chief Justice made the secret intelligence reports about security risk attorney or lawyer Saurabh Kirpal poses to the state of India because of liaison with a Swiss agent, spy. Now, that is the issue, that Supreme Court and Chief Justice Chandrachud made public intelligence reports from Intelligence Bureau and RNAW. Now, this puts the life of officers of Government of India who risk their life to find intelligence, to work in the realm of national security. Very flippantly, Supreme Court decides to do away with their rights and their safety. So the question is why Justice Chandrachud is showing this indecent haste and not letting the legislature, which is a deliberative body, which is supposed to look into complexity of the arguments, take its own time. What is this hurry?
Aditya, maybe we are at the top of the hour. So if you want to.
I think we have run out of time, and it is unfortunate because of storm, power outage, connectivity was lost, and we lost Madhav Tripathi ji. But it has been a good discussion. I think we have to work on the issues of separation of different branches of the Republic. And legislative and executive branch need to assert for their own rights. And in that sense, Subhashi has given certain suggestions. One is bringing back the NGAC. Second is pass a law on judicial code of conduct and accountability, which is not there. And simply maybe pass a resolution, sense of the parliament, about where the limits are. The legislative body cannot be dictated by the Supreme Court to bring out a law, or Supreme Court should not make the laws. Their job is to just interpret the laws. So with those closing comments, I'm going to end the meeting. I'm very thankful to Mr. Subhash Jha. I'm also thankful to Madhav Mukul Tripathi, who joined us, and while he joined us, there was an electricity failure, and we saw total darkness. And he sent me several messages that he is very sorry, he has no connectivity, no network, no electricity in his house, but he will be reviewing the recording of this particular session. And we might arrange several sessions on judicial reforms in India. So this would not be the end of it, but I'm very thankful to Subhashi.